From daily list, item number 1 for pronouncement of judgment.
I have passed a common judgment in both cases. All things said and done, I think according to this court, there's a misconception in calculation of the financial upgradation. So according to this court, the petitioner are correct in their calculation, though all the prayers have not been allowed. I'll just read out some of the portion. In the final analysis, this court hereby find that the petitioners have made out a case in their favor to the extent indicated herein above, and the prayer made in this regard is allowed. The respondent authorities in the NEHU are hereby directed to take necessary steps by passing relevant orders to correct the anomaly made out by granting the second and third financial upgradation to the petitioners herein, and to make necessary arrangement for payment of arrears, etc. in this connection. Steps taken should be done within 3 months from the date of receipt of certified copy of this order. The above these petitions are hereby disposed of course. Thank you.
Please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. Taking the consent of
What is this case about?
Your Lordship, here the petitioner was working as a librarian in Tura Polytechnic, and she was removed from her job, Your Lordship, and someone else was replaced. So after 2 weeks, Your Lordship.
On pre-made by the petitioner, this is matter to 2 weeks.
Thank you. May I please, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. I humbly pray this matter be taken after 2 weeks, Your Lordship. In this matter, we need to file the chart, Your Lordship, regarding this relevant information of the name of the employees, Your Lordship, regarding the EPF Act. So we have tried to contact the clients, but we could not reach, Your Lordship. We need some more time, Your Lordship.
You are for?
I'm for the petitioner, Your Lordship.
On pre-made by the petitioner, this is matter up to 2 weeks.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 13, Lordship.
This matter has been heard, isn't it?
Yes, Lordship.
Was
Due
it
to some
heard?
personal difficulties, yes, Lordship. It has already been heard. I'm praying for 2 weeks' time, Lordship.
See, once the matter is heard, it's kept part heard. The next time it comes, this court will still be in a position to understand or at least remember the facts or the law or the arguments of the party. Now, if it goes on to another date, you have to start over again. Anyway, on pre-made by the appellant, this is matter after 3 weeks.
Right. Obliged, Lordship.
May it please Lordship, I beg to mention this item 12. Also, I'm praying if this matter can be taken up after 2 weeks, Lordship. This matter.
Why?
Lordship, senior counsel has some difficulties, Lordship. Some part-heard matters are there, Lordship.
On pre-made by the petitioner, this is matter to 2 weeks.
Obliged. Deeply obliged, Lordship.
Item number 2.
Lordship, may I please, Lordship?
Oh, this is for implement.
Yes, Lordship. I require some more time, Lordship, to find necessary implication, Lordship.
2018 matter.
Yes, Lordship.
You see, all these issues should have been thought of. In the course of proceeding, you should know, you see, the stand of the party should be made clear as to what is required to be done. The fact end of the proceedings, you come and say, no, this is, sometimes the parties will come and say, we have not filed a counter affidavit. Sometimes you will say, we have not filed rejoinder. Now, when the issue of, those teachers who have been said to be, who have been, appointed in your place.
Yes, Lordship.
Now you have come with the plea that they may be. Have you got the list?
Yes, I'm not sure, Lordship, because
last time I believe the name of those people who have been appointed in their place had been furnished by the Council of the Managing Committee.
Managing Committee.
Lordship.
Was it filed? I mean, has it been brought on record?
I think so. The problem is that, Your Lordship, there is a change of council. In one day, one council will come, on another day, another council will come. Then
This will
problem
not do.
arises, Your Lordship.
It doesn't matter. You see, whoever comes, he should be well briefed.
Should, Your Lordship, yes.
He should be, he should be, aware of the facts and what are the proceedings.
Actually, Lordship, they're supposed to file the implement application.
Oh, that is not the query of this court. The query of this court is, in the first place, if you say that there are some teachers, because there are a number of cases here,
Lordship, yes.
some teachers who have been appointed when some of the petitioners have been, ousted from service. So that list, firstly, you have to,
You have
produce
got the
that
list. You have got the name of the people.
Secondly, it would be incumbent upon the petitioner if they chooses to implead the newly appointed teacher or those have been appointed, that will be upon them. Whether they do it or not, it's up to them. But you have to do your duty, they have to do their duty. That has not been done.
Lordship, I think the name of those people had been furnished to the council.
They have furnished. Only that address is not there, but they have put the address of the school.
Oh yes, I think that was
School, and the court was, what you call that, I have raised the objection saying that they should furnish the list of the, furnish the details of the,
residential address.
yes. Only they have given the name of the school.
I think the school address is
Then I'll
sufficiently enough, Your Lordship.
Because you see, if they are teaching, I think the opinion, I have said
Yes,
this last time.
yes.
If they are teaching in that school,
Yes.
you send it to the school.
Then I'll take, some time may be given, I'll take necessary step, Lordship. Because I have to file application for impleadment. Otherwise, if the court has the power to implead.
Once they are, you see, if they are proper necessary parties, the court will do so.
Yes, Lordship.
But that would be to your prejudice. If you find that they are not necessary parties,
That's
then
why what
it is for you to
yes,
decide.
what I am saying, Lordship, they are not the necessary party. Now see, I am only on the order of my termination, Lordship. Now I cannot challenge the order that because their termination is not on the court cannot scrutinize unless separate writ petition is to be filed against their appointment. Now here I am only on the legality and illegality of the order of my termination.
See, Mr. Sheikh, that is true. You have come against your termination. Suppose the case goes in your favor and the court directs that you be reinstated. What happened in the meantime? Because there's already an incumbent there.
Now
Somebody is
Lordship,
already functioning. So what do you do with that?
Lordship,
The court cannot pass an order without records.
Lordship is correct, Lordship. My Lordship has handled so many order of termination like this case. Because in that eventuality, if I succeed, then their appointment automatically will go, Lordship.
No, that is not the case. Once a person has been appointed in due process, that person would have acquired
That
a
is
party
the
right.
issue, Lordship. Now that is the issue because see now whether their appointment was made due process or not. No advertisement, even they are not eligible.
Exactly.
But
It is because of that that you have to challenge that
But
process.
now I cannot challenge my lordship. How can I challenge in this proceeding, lordship? Now they have not given they have not raised that issue also. Since 2018 the matter was pending. They have filed the counter. In the counter also they did not say that this that I have to challenge or I have to make them party. Now how can I in this proceeding can I challenge their appointment, lordship? That will be different set of proceeding, lordship. That is why I am saying, because lordship,
But the fact remains.
I can make the party, lordship.
The fact remains that this is the situation. This is the situation. Mr. Shulai, the government has to approve their appointment.
Yes, certainly.
Have it been approved?
Lordship, let him file, then we'll have instruction
No, as
accordingly.
far as that is concerned, as far as his
I
part
think,
is concerned,
I think there should be, without prior approval of the government, no appointment can be made, Your Lordship.
yes, suppose, you see, the petitioner has been ousted from service, a process has been followed, somebody has been appointed, and you have to approve that appointment.
Lordship, yes, certainly, Your Lordship.
If that is done, that means due procedure has been followed. So
Due
you have to
procedure
challenge
is
both the
lordship.
action of the managing committee and the government. Well, what happens, see, Mr. Sheikh, you understand?
Yes, I understand, lordship.
What happens is even if the court decides in your favor, you still have to go through another proceeding of filing a case to.
Immediately, Lordship, they will come and file a review.
No, then I'll implement then, lordship. I'll implement.
Immediately, they will come.
I'll take necessary step, lordship.
2018 matter.
Because
please
in this repetition, I cannot challenge their repetition, lordship. Because challenging will be altogether different issue, lordship. Whether procedure has been followed. Because here only on the
only thing is that it has come to your knowledge.
Yes.
Yes. Somebody has been appointed in your place to safeguard your interests as a abundant precaution.
I'll take necessary
you
step.
take steps.
I'll file
And the
necessary.
court will decide.
Yes,
the
lordship.
parties will raise their.
At least
contention.
they can have the opportunity to participate also. Tomorrow they cannot say that yes. Two weeks, lordship. I'll take necessary step, lordship.
Mr. S.A. Sheikh, learned counsel for the petitioner, has submitted that the petitioner
Which item you are referring to? Only 2, 3, 4, 5, and 6. 2, 3, 4, 5, and
has
6.
70, no,
come to learn that
No replacement.
pursuant to his being ousted from service by virtue of the by the impugned order of termination, it is now reliably learned that another teacher has been appointed in his place. The particulars of such teachers has now been received by the petitioner, who seeks time to take necessary steps in this regard. As prayed for, prayers allowed, let steps be taken let the matter be now posted after 2 weeks for the petitioner to take steps as prayed for.
2 to 6, lordship, same order, and
Same order?
Yes, 7 and 8 because there is no replacement, lordship.
just list along, Your Lordship,
Yes,
with
list
this.
alone. 2 to 6.
Can it we cannot separate 7 and 8?
No, my lordship, the pleadings are more or less is same, lordship. Otherwise, if my lord,
Because you see what happened is,
yes, that
if we can separate those two, deal with those matter, because this, remember, see, again, time and again, this court would say that this is a very old pending matter. If we keep on postponing,
True, lordship.
so if all the parties agree, so 7
Yes.
and 8 will be taken up
True,
separately,
True,
dealt with separately.
true, lordship. That will be.
So we'll take up 7 and 8 then.
7 and on the next day I'll do Lordship. Because in fact I was of the
So let it come after 2 weeks, then, your
Lordship on
lordship.
the
Mr. Sheikh, you see,
Let it come along with all with
if-
item 2 to 6, your
if the
lordship.
party, if the petitioner lose or win, you'll be blamed.
Lordship on the next date I'll do the 7 and 8 I'll do. In fact it has been hard in fact, but still I'll refresh the memory of the court Lordship.
That's what
Yes, yes.
I was remarking just previously. That once a matter is heard, if it continues on the next date, you see the facts are still fresh with the court. If it goes to the next date after that, then you have to start
Because that item number 2 to 6 might take time, because again there will be actions of pleading. So 7 and 8, if the matter is taken up separately, on the next day I'll do Lordship.
So 7 years to list the matter up to 2 weeks.
Obliged,
I'll do on the next day.
In fact, what we do is, I think we should fix a date for this. Ano tarik matasi?
24.
Today is 24th, your lordship.
4th.
24th.
I'll file it. I'll not ask.
We'll fix this matter on 9th.
9.
List this matter on 9th.
I'll file it.
And no adjournment.
Yes, no Lordship. I'll take it.
Obliged, your lordship.
Item number 9.
226, 78. Fixed date.
Lordship, this matter is fixed for submission of this written argument, Lordship. Written argument, Lordship.
Yes.
Written submission.
What is this matter about?
Lordship, this is that
It's about promotion from
promotion
promotion
matter.
Gram Sevak grade 1. Then
Oh.
they want us without surpassing this Gram Sevak grade 1, they wanted to become the senior grade
notional
senior grade.
promotion.
1. And he was working as a senior grade 1 only for 2 years. He wanted to go to senior grade without completing 5 years. That is the case, Your Lordship. Because he has to serve, he has to complete 5 years as senior grade, senior Gram Sevak, then he can become Gram Sevak grade 1, then he can be promoted to the senior grade 1.
And a counsel for the parties, for the respective parties have filed their, for the parties have filed their written, respective written submission. Accordingly, this matter is now reserved for judgment.
Hello, Prince.
Item number 11.
Lordship, this is the termination of service matter, Lordship.
Yes.
Lordship, this matter, Lordship, the petitioner was appointed from 2006 in a sanctioned post, Lordship, as a temporarily in a sanctioned post.
School teacher.
School teacher, Lordship. She was terminated from service after more than 12 years in service, Lordship.
Fine. You go through the facts.
Lordship, this the prayer in this petition is twofold, Lordship. One is for regularization and one is for according another opportunity for obtaining that NET
We'll see what.
exams, Lordship.
We'll see what are your submission and what's your case.
Yes, Lordship. So,
Start from the beginning.
Lordship, the brief fact of the case is that, Lordship, the petitioner was appointed as a substitute teacher at Langpi LP school initially, Lordship. Initially in 2006, Lordship. Thereafter, Lordship, she was again appointed as a substitute teacher at
Where is
Langja.
that initial appointment order?
Initial appointment order is at page 28, Lordship.
Page 28.
Page 28, Lordship. If I may read, Lordship.
Just a moment. Annexure 2.
Annexure 2, Lordship.
Please.
Also, under the authority conveyed by the Director of Elementary and Mass Education, White, so-and-so, Shri Fulbidora K. Lingdor, PU is hereby appointed as a substitute teacher at Langpi Government LP School against the post of leave vacancy caused by Shri Principal K. Lingdor LP School or LP teacher or on contract basic so-and-so for 59 days, Lordship. And the appointment is purely temporary for 59 days. So this is the initial appointment, Lordship.
Yes.
Initial appointment, Lordship. Thereafter, Lordship, the writ petitioner has been serving in the said school, Lordship, for more than 10 years, Lordship. At at Langja LP School, Lordship. Langja LP School. And page 30, Annexure 3, Lordship. This is the another appointment letter, Lordship, which was issued by the DS.
That earlier appointment order was dated 28.
Earlier dated 1st July, Lordship. 1st July 2007.
Yes. And this one is?
Lordship, the second one was on 2008, Lordship. 1st September 2008.
Yes,
but,
what?
Lordship, the teacher has been serving in the school since 2006, thereafter, without any interruption, Lordship. There was no formal appointment initially, but then subsequently they issued this appointment letter, Lordship.
Yes.
Initially, she was appointed as a substitute teacher, Lordship. There was no formal appointment initially. And thereafter, Lordship, after she has been serving for several months and after a year, this appointment letters came into being, Lordship. And then subsequently, this another appointment letter, 1st September 2008, Lordship.
First September
2008, Lordship.
Yes.
Lordship. And then again on 2009, Lordship, she was again appointed as a substitute teacher, Lordship, in the said school.
This is
against this leave vacancy caused by Shri Principal K. Lingdor, Lordship, because he, Lordship, and then
this is the third.
This is the third, Lordship. And Lordship, Annexure 5 is the letter which was issued by the Deputy Inspector of School Longstein, Lordship. Kindly have Annexure 5, Lordship.
Yes, what does it say?
Lordship, if I may read.
Yes.
This is to certify that Srimati Fulbidora K. Lingdor has been teaching in Langja for quite some time. She is experienced and active teacher. She is qualified to be appointed as primary school teacher in place of her uncle, who is willing to apply for voluntary retirement to enable her to have this post. As an active and qualified teacher, I recommend that her case may be sympathetically considered. this is the recommendation made by the Deputy Inspector of School, Lordship, after he has found that she has been teaching in the said school for quite some time, Lordship, and against this leave vacancy, Lordship, caused by her uncle. Lordship, Annexure 7, Lordship, is the NCTE notification, Lordship. Stating that this
Where is the
page,
translated?
so this one, page 39, Lordship, 39A. Lordship, this notification came into
Yes.
yes, Lordship, on August 23rd, 2010, Lordship. It came into being, Lordship,
Yes.
whereby the minimum qualifications was stipulated, Lordship. And Lordship, kindly see this point number B. Lordship.
B.
Yes, sir. Yes, Lordship. Pass in the teachers' eligibility test to be conducted by the appropriate government in accordance with the guidance framed by the NCTE for the purpose, Lordship. Lordship, this notification came into force in was published on 23rd August 2010. Lordship. Thereafter, Lordship, the norms was, the guidelines was framed subsequently, Lordship, in Annexure 9, Lordship.
Page.
Lordship, page 45. For the first time, Lordship, these guidelines were framed, Lordship, on 2011. But thereafter, Lordship, the exam for TET was never conducted, Lordship. It was conducted only on 2018, Lordship.
Yes.
Lordship, kindly
So
see,
these guidelines were issued,
by the state, Lordship.
yes, dated 11 February,
Lordship, 11 February 2011. Lordship.
issued by the state or the center.
By the central, Lordship, NCTE,
This is applicable throughout the country.
Lordship. But
So according to this guideline, a teacher who would be qualified
yes, sir.
to
Yes,
teach
Lordship. Actually,
in a school.
the state will have to conduct the exam,
The state
Lordship,
would have to
according
conduct
to
it.
this.
So a teacher would be qualified on passing this TT.
Lordship, on passing this. But Lordship, prior to this one, the teacher was appointed, Lordship.
Of
Prior
course,
to this.
naturally, if the
Lordship.
NCT qualification has not been in place, then naturally some other rules would be applicable.
Lordship, in view of that Uma Devi's case also, Lordship, that's why, Lordship, this petition was filed, Lordship, because she has been in service for more than 12 years, considering. Lordship. And then this Annexure 10, Lordship, page 51. This is her dated 1st July 2011, Lordship. Another appointment letter, Lordship, by the Deputy Inspector of School.
This is dated
2011 Lordship. 1st July 2011.
yes.
It is to be noted, Lordship, that even though these appointment letters were issued from time to time, but the teacher remained teaching in the school from 2016, Lordship, without any interruption, and she has been receiving her daily salaries, Lordship. Annexure 15, Lordship, page 62.
Yes.
Lordship, this is another appointment letter, Lordship. Lordship, this is dated 16 August 2017.
2017.
17, Lordship. 2017. 16 August 2017. Serial number 4, Lordship.
Yes.
Simiti Fulbidora. Thereafter, Lordship. Annexure 22, Lordship, page 80, Lordship.
Yes.
Lordship, this is again another appointment letter, Lordship. This is in 2019, 19 August 2019, Lordship, dated. Even though this appointment letter has stipulated that she is appointed for 59 days.
Yes.
However, Lordship, she continued in service without any interruption, Lordship.
Yes. This is 19/8/2019.
2019.
So it appears that she has been, appointed
from time to time.
From time to time,
Lordship.
and at an interval of 1 year.
1 year.
It appears.
Lordship. But every year she gets her appointment letter, Lordship.
Every year.
And though it was mentioned for 59 days,
Yes.
but she continued in service month after month, Lordship, and without any interruption, she has been receiving her daily salaries also, Lordship. Daily salaries. And Lordship, this Annexure 27, Lordship, page 88.
Date.
88, Lordship. Dated 19 October 2020. This is her last appointment, Lordship. serial number 4, Lordship, at Langja Government School. This is her last
Why you say last
appointment,
appointment?
Lordship, because they have stopped paying her the salaries, and also considering that she has filed a representation before the SEO for regularizing her service, and the SEO is adamant, Lordship. He remains silent on the representation which was put forward by the petitioner, Lordship. Therefore, she came before this honorable court for directions to direct the SEO to dispose of her representation, Lordship. And what happened, Lordship?
So was that that was in
No,
earlier
Lordship.
round of litigation?
In the earlier round in the second round of litigation, Lordship.
What was the order pass?
Lordship, kindly come to this page 21, Lordship.
Which?
Page 79, Lordship.
79.
Lordship.
Yes.
Lordship, the last paragraph, Lordship.
Yes.
After hearing the learned counsel for the parties and perusing the writ petition without expressing any opinion on the merits of the controversy of the writ petition, the writ petition is disposed of at this stage by directing the respondent number 2 to take a decision on the said representation forwarded by the respondent 3 within 2 weeks from the date of receipt of the certified copy of this order, and to pass a speaking order after forwarding the opportunity of hearing to the petitioner in accordance with law. Here, Lordship, the recommendation was made by the Inspector of School, Lordship, to the learned to the SEO, Lordship. Thereafter, Lordship, the reply to the representation is at Annexure 12, Lordship, page 57.
Let me see.
Also, kindly come to Annexure 13, Lordship, page 58. Page 58, Lordship.
This one. That page 79 is, you are referring just now, is the order?
Order passed by this honorable court, Lordship.
WPC 264.
of 2019.
So now 57 is, so Annexure 12 is what?
Annexure 12, Lordship, this is the letter which was issued by the SEO, Lordship, stating that for appointment of these teachers in this set school, Lordship, certain minimum qualification criteria as prescribed by the NCTE norm is required, Lordship.
Yes.
And therefore teachers will have to undergo those teachers eligibility test exam, Lordship.
Yes.
And then Annexure 13, Lordship, page 58.
Just one. Page
Page 58, Lordship.
Yes. 58.
Lordship. This is the representation which was made by the dread petitioners, Lordship, before the SEO, Lordship, for regularization of appointment, Lordship.
This is the petition.
This is the representation, Lordship.
Okay. Dated.
Lordship, this is the
31/5/2016. Look at your signature.
Yes, Lordship, 31/5/2016, Lordship.
So, you see, this representation was not considered or not
Was
taken
not
up.
considered,
Not
Lordship.
taken up.
Lordship.
Eventually, the court directs the relevant authorities
Yes, Lordship, to
dispose of this
dispose of the
by that order dated
Lordship.
page 79.
Yes, Lordship. So I'll come to the reply, Lordship.
Yes.
Lordship, Annexure 19, Lordship, kindly come to page number 76. Proposal for regularization of service in respect of Sri so and so under the contractual basis at Langja LP School.
These are just proposal. You see,
Lordship.
first you show this court on the basis of the order at page 79.
Lordship, I'll come to that, Lordship.
What has been done?
Lordship.
They have disposed of your representation.
They have disposed of, Lordship, but they have not disposed. Lordship, I'll come to the disposal order, Lordship.
Please.
Annexure 23, Lordship. Annexure 23,
Page.
Lordship, page 82. Lordship. In pursuance to the Honorable High Court Order so-and-so, the representation of Srimati so-and-so has been examined as per the High Court orders. She was given an opportunity to present her case white so and so. Accordingly, she appeared before the office of the Directorate of on so and so on hearing on what, and hearing was conducted by the Deputy Director, who was in charge of the office of the Directorate during my leave. The written statement of the petitioner given herein, given during the hearing, is enclosed herewith. Also, this paragraph number 2, in the second paragraph, Lordship. Further, the order issued white education on department letter so and so was also examined, wherein it stated regularization of the petitioner can be done only after being selected through open competitive exam, and the petitioner would be given a chance to participate in the select process when advertised. In view of the direction issued by the Education Department, which is the administrative department, the prayer for regularization of service of Sri so and so officiating assistant teacher government LP school cannot be considered at this juncture. And accordingly, Lordship, the representation filed by so and so is hereby disposed of. So my regularization was never considered, Lordship, even after filing the several recommendation proposal and after putting up the representation before the TSEO, Lordship. And Lordship, there is a
So after this, what did you do?
Lordship, after this, Lordship, my service was discontinued. Lordship, thereafter I withdraw that repetition and I filed this repetition, Lordship, challenging my termination order, Lordship. However, Lordship, there was no formal termination order. It's just that the service was discontinued, Lordship, and they have stopped paying my remunerations, Lordship.
Where is that order?
Lordship, the order is not there, Lordship. It's just this last appointment order is there, Lordship.
How can it be?
So here, Lordship, this repetition basically challenging the non-proper consideration of my representation, Lordship.
Now you say you have withdrawn that representation.
Lordship,
In fact,
it
not
appears,
withdrawn.
Lordship.
Not withdrawn. The fact remains that after the order was passed, wherein your representation was not considered,
Lordship.
you have not,
Lordship,
you have not taken
actually, Lordship,
the matter further.
Lordship, this is the third round, Lordship, of litigation. First round was considering that representation. Secondly, Lordship, after my representation was not considered properly, I again come before this honorable court in the second repetition, Lordship. And in the second repetition, Lordship, the last order is at page 90, Lordship. It's again for regularization only, Lordship. Also, if I may read first,
Just a moment.
page 90, Lordship, Annexure 28.
Yes. So
Lordship, heard Mr. So and so, learned counsel for the petitioner, Mr. So and so. Petition is filed for regularization of the service of the petitioner who claimed to have served with the respondents as assistant teacher since 2006 on temporary basis, Lordship. And this para 3, Lordship.
yeah.
It is not disputed by Mr. B. Kriam. And so learned counsel for the petitioner that during the pendency of the petition, the service of the petitioner are discontinued, and the petitioner has rendered infructuous also. And faced with the above difficulty, Mr. So and so learned counsel for the petitioner seeks leave to withdraw the petition with liberty to challenge the termination order for the petition of the petitioner leave with liberty as spirit for granted Lordship. There was no termination order Lordship saying that the service is terminated and expired. It's just that it was discontinued based on the last appointment letter Lordship.
When is the last appointment order?
Lordship, the last appointment letter is at Annexure 27.
27?
Lordship.
Page
88.
Okay. So, what does this say?
Lordship, this simply says that I'm again appointed
No,
for a period of 58 days.
Look at the last line, yes. It says
Teacher for the period of 88 days.
last page 89.
Yes,
The
Lordship.
last line says appointment is purely temporary
Yes, Lordship.
arrangement
Yes,
which
Lordship.
stands cancelled, terminated after the hereby.
Yes, Lordship. But fact remains
So
that
see, this
appointments have been coming. There have been several appointments.
whatever the case
year
may
after
be,
year,
see,
Lordship,
whatever
but-
the case may be,
Lordship.
you have been appointed for a period of
59 days. Lordship.
59 days
Lordship.
and reappointed from time to time.
From time to time, Lordship. Since
But-
2006,
Yes,
Lordship.
but the fact remains
Lordship.
that such kind of appointments are purely temporary.
Purely
So it
temporary.
is not your discretion.
Lordship.
It is the
But
discretion
considering
of
the duration I've been in that service, Lordship.
that is immaterial.
Lordship.
That is immaterial.
Lordship. And
In the
there-
sense that,
if I may-
see, Mr. In the sense that
Lordship.
you have to look at the nature of your appointment. If it is for 59 days, 59 days. If it is extended, well and good.
Lordship.
If it is not extended, you have no case.
Lordship. And it seems, Lordship, after doing some research and all, Lordship, I've come across one case, Lordship, which was disposed of by this Honorable Court, Lordship. If I may show,
Yes.
Lordship. It may be,
On this issue,
Lordship, the issue is quite similar, Lordship.
so it all boils down to only this point.
Appointment, Lord.
Only this point.
Appointment.
That you have been appointed
from time to time.
time to time,
But I've been in
for a
service
period of 59 days,
uninterruptedly, Lordship.
uninterruptedly, whatever the case may be.
Lordship.
But eventually, though no formal
Though no formal termination letter was there,
but
appointment is there, Lordship, stipulating that I was appointed for 58 days,
on
59
the basis
days.
of this page 89, it has been
Lordship. It has been terminated, Lordship. This, Lordship, it appears that this is also a similar case, Lordship, whereby this writ petitioner in this matter, Lordship, was appointed on a temporary basis.
and subsequently discontinued.
Subsequently, Lordship, they have converted his appointment letter into a contractual letter for contractual basis for 59 days.
Okay.
Similar, Lordship. And thereafter, Lordship, after filing this writ petition, this court, Lordship itself, regularized his service, passed an order for regularization, Lordship.
How can it be?
Lordship, if you para 7, Lordship.
Yes.
Lordship, on bare perusal of the said order, it is understood that instead of considering for regularization of the petitioner, the respondent, number 2, had taken a divergent view best known to him and directed to break the service of the petitioner intentionally without any reason, which is purely a discriminatory and injustice cause against the principle of natural justice and equity. Therefore, the impugned order is not maintainable and is hereby quashed, and the service of the petitioner is to be counted from the date he is serving, so and so, and the respondent number 2 is further directed to regularize the service of the petitioner within 2 weeks. Lordship. Here, Lordship, what happened? He is similarly, Lordship, he is appointed on a temporary basis. Lordship. Temporary basis, it was not permanent, Lordship. Later, what they did, they have converted his temporary appointment into contractual for 59 days, Lordship. Thereafter, he continued, Lordship, but after putting several representation before the SEO, he refused to regularize, Lordship. Thereafter, Lordship, he comes before this Honorable Court and this order was passed, Lordship. So,
Thereafter, he
it's
was.
a short order, Lordship.
Thereafter, his service, I mean, in this case, the service was regularized.
Regularized, sir, Lordship. He is there, Lordship. He's teaching, Lordship. So, Lordship, therefore, Lordship, para 53 of the Uma Devi's case also, Lordship, this petitioner has a right to be regularized, Lordship.
What does paragraph 53 says?
Lordship, that para 53, Lordship, today I could not get the judgment from the library, Lordship, if I may place it subsequently, Lordship, that one. Because, Lordship, today morning, Lordship, it was not available in the library, Lordship. So,
You should have come prepared.
Lordship,
You should have come prepared. Now,
I
the
apologize,
already-
Lordship, for that,
hearing is already concluded.
Lordship. So, Lordship, this person, Lordship, in this case, he's teaching, Lordship, his service is regularized, Lordship. Therefore, Lordship, I'm trying to place reliance, Lordship.
Who's appearing for the state?
And the teacher's eligibility test exam, Lordship, it was not conducted on a regular basis, meaning like it was conducted once after 3 years, Lordship. It was never conducted every year, Lordship.
Yes, Mr. Pustaji, I think
My lord, firstly, my lord, I will draw my lord's attention to page 3, para 4 onwards of the affidavit in opposition, which is filed by the state, my lord. So you've explained everything in detail, my lord. If I'm allowed to go through.
but you see, Mr. Pustaji,
My lord,
all said and done.
my lord.
What was this order?
This is not applicable in the case of petitioner at all, my lord.
You have to distinguish.
My lord, because this order is not before me, he is not given us a copy of this
You have to
order.
distinguish. Because you see,
Nevertheless, my lord.
you know very well, if it is an order passed by a coordinate bench, if it fits the facts and circumstances of this case,
My lord, in my respectful submission, my lord, it will not fit. No, my lord, I will narrate the events, my lord, of the actual facts in this case, my lord. My lord will thereafter, my lord, I'm sure my lord will be convinced, my lord, that this case has no relevance.
see, what is understood is that the petitioner was firstly appointed as a substitute teacher.
My lord, the petitioner was always appointed as substitute teacher, never otherwise, my lord. In place of her uncle,
Yes.
whenever his, her uncle was on leave vacancy, she occupied that post.
But how do you contemplate
My
a
lord.
situation where the regular teacher, uncle or otherwise, whatever the case may be, is on leave for months on end, for years on end, in fact.
My lord,
How
but
do you
in this
contemplate this?
situation, that is not so.
Well,
my lord.
her appointment was, it appears, was renewed at an interval of 1 year. 16, 17, 18, 19.
My lord, she has not produced any. Only record she has produced, my lord, is my lord at the end of the annexure. My lord, that is annexure 27, page 88.
So I've already pointed out several appointment orders.
My lord, yeah, allow me to go through the separate appointment orders, my lord. So let's start with, my lord, if I'm allowed to start with page 28, annexure 2.
Yes.
My lord, it says under authority, whatever, my lord, if I take my lord to the end, my lord,
Yes. 59
only
days.
for 59 days. With
With
effect
effect
from
from-
now, in place of whom, my lord? Caused by Principal Sri K. Lindo.
Yes.
K. Lindo is her uncle, my lord.
Exactly.
So this is 59 days, once in 2007. No, my lord, once in 2008.
So now what happens?
She's a substitute teacher, my lord.
See,
She
now,
does not have any right.
See, now, this court doesn't have the, rather the parties have not been able to produce the records. You can produce the record if you have it with you.
My lord, these,
That as according to Annexure 2,
yes,
she was appointed with effect from 1/7/2007
yes,
with for 59 days.
yes.
So thereafter
It ended there.
it ended,
Yes.
and then subsequently again she was appointed
In the year
on 1/9.
2008 as a substitute.
So that is the situation you have to.
Substitute teacher again, my lord. Again for how many days? 59 days.
Yes, but
With effect from what, my lord? 1/9/2008 to 28/10/2008.
yes, that's true. That's true. But what see the picture that the petitioner has presented is that she was continuously.
Lordship, can you have my
My lord,
rejoinder?
my
affidavit
respectful
at
submission
paragraph
at this stage, she cannot even go into that. Why, my lord? Because earlier she had approached this honorable court for regularization. There was a direction that, okay, fine, you file a representation. Representation was filed. Thereafter, my lord, second round of litigation, opportunity was given to her to sit for, state government said, okay, fine, we'll allow you to sit for exams. If you qualify, you will be regularized. She sat for the exams also. She did not qualify. So the matter ends there, my lord. Stated that is exactly why, my lord, I wanted to refer to our affidavit in opposition, because she cannot go back there. That episode is over, my lord.
The petitioner, the learned
kindly
counsel
have
for the
my
petitioner
rejoinder
has
affidavit,
also
Lord.
stated in here, has also presented those facts that she has in fact forfeited the process of regularization after this court's order, and pursue with the issue of termination of service. That is what.
No,
I
my
feel.
lord, that is, if I, my lord, kindly allows me to read my affidavit, my lord. Page,
Before
Three.
he starts, Lordship, can you finish with
My lord,
my
he
rejoinder
can-
affidavit, Lordship?
my
Kindly
lord,
come.
I'll have to refer to my affidavit first, then he can refer to his rejoinder, my lord.
But you have not come with your authorities.
Lordship, that
My
Uma
lord,
Devi's
petitioner
case,
has
Lordship, I will.
no legal right, my
Uma
lord, no
Devi's case,
legally
Lordship, I
vested
will
right.
subsequently produce, Lordship.
How Umar Devi's case would be involved here?
Lordship, in this petition, we
My
have
lord, law
strongly
is very
relied,
clear. Any
Lordship, on
backdoor
that.
entry has to go out. And my lord, this consistent fact that she is a substitute teacher. What is her legal right, my lord?
Lordship, in fact, this petition was filed, Lordship, on the basis of that order, Lordship, of Uma Devi's case, Lordship.
You will take it up after 1 week. Then. You bring your
Lordship, I'll bring the authorities.
whatever, and we'll look up. But you give him a copy of
Lordship,
this.
I'll give him the copy, Lordship.
Just look into this. Just look into this. Because this will have
This
a
is
very.
not disputed, Lordship. This petitioner here has been regularized, Lordship.
My lord, here is a case of substitute teacher. My lord, only one.
Yes,
My lord, I will take only 5 minutes of this honorable court. My lord, this matter may be taken up next week, but only one para, my lord, I want to draw
Please.
attention of this honorable court.
Para 3.
Para 4, my lord, which is at page 3.
Managing committee is here.
No,
You have not
Managing committee was
not involved.
it's irrelevant, Lordship.
not
She's
made a party. My lord.
Not relevant.
Not relevant.
Not made a party. My lord.
Lordship is not relevant, Lordship.
Because the appointment
this
was
is only the
given directly by
appointment
the
State lordship.
SO.
Yes, Lordship.
Para 4.
Para 4, my lord. If I am allowed to read, my lord. That before controverting the claims, averments, and allegations of the petitioner herein, certain brief facts may be brought to the notice of this honorable court. In this regard, it may be stated that this is the third round of litigation. The petitioner had initially filed a writ petition bearing WBC number 264 of 2019, praying for regularization of her service, which was disposed of at motion by the honorable court, vide its judgment and order dated 22/7/2019, whereby the respondent number 2 therein was directed to take a decision on the representation of the petitioner dated 30/7/2018 for regularization and pass a speaking order for affording opportunity of hearing to the petitioner in accordance with law. Thereafter, or the next page, thereafter, pursuant to the Honorable Court's direction dated 22/7/2019, passed in WPC number 264 of 2019, the representation of the petitioner was thoroughly examined, and the petitioner was also served with notice dated so and so as to afford her an opportunity to present her case.
Accordingly, the petitioner appeared before the Director of School Education and Literacy on 4/10/2019 and her statement was recorded. The petitioner was also made aware of the fact that as per government order, regularization is done only after a candidate is selected through a proper selection process. The petitioner, on the contrary, was a temporary contractual appointee who was appointed only as a substitute teacher on certain occasions. However, on representation of the petitioner, the Director of School Education gave a thoughtful consideration and came to a finding that a prayer for regularization of the service of the petitioner cannot be considered, but the petitioner would be given a fair opportunity to participate in the selection process as and when the said post is advertised. Accordingly, the representation of the petitioner was disposed of, dated so and so. It is pertinent to mention herein that these facts were brought on record in the state affidavit filed in the subsequent writ petition filed by the writ petitioner bearing WPC number 487 of 2019, and the said writ petitioner was disposed by the Honorable Court as infructuous. It may be stated that the petitioner herein has no legal vested right to be considered for regularization, more so in a last temporary appointment for a period of 50 days, vide memo number so and so, Annexure 27 of the writ petition stood expired after the completion of the term. No further extension has been granted thereafter. So this is just to draw my Lord's attention to the fact.
Anyway, that aspect will be looked into. But the only query of this court, you see, it is not clearly understood from the materials on record. The assertion of the petitioner is that she was in continuous service by virtue of that initial appointment order.
Then she has to prove it, my Lord.
Yes, she has to prove it, no doubt. Yes. So if that is the case,
because her own record reveals otherwise.
Because it would be proper for the authorities concerned on the expiry of 59 days to issue another appointment order for another 59 days. I think that would be the norm.
Yes, correct. My Lord, what would happen is that here, because that is what our stand, my Lord, her appointment is not at all continuous.
Exactly.
Yes. Because as and when leave vacancy was there, yes, as a substitute teacher, she was appointed.
Also, I've stated in
that would be the picture that is presented.
Because even her own record, my Lord, reveals that it's not regular. Also, once in 2007, once in 2008.
Yes, but you would say that you are in continuous.
As per I've stated in my rejoinder also.
Just stating will not help, my Lord. She has to produce through records.
There's a certificate which was issued by the Deputy Inspector of School also, Lordship, which I have annexed in my rejoinder affidavit.
Which says that
certificate?
Which says that you've been in continuous,
no, Lordship,
service.
stating that I have been, Lordship, if you kindly have my rejoinder affidavit, Lordship. Annexure 1, Lordship. Page 10.
Yes.
So this is to certify that Sri so and so is serving at LP.
Srimati or Shri?
Srimati, Lordship. Srimati Fulbidora.
Yes.
Salingdor, Lordship. In the scale pay of rupees so and so, his or her date of birth is joining of the post is 2007, and she will be retired from service on
anyone can get this certificate,
35, Lordship.
This certificate is of no relevance.
You should see, Mr. Bhattacharya, this is a certificate issued by a responsible government official.
Lordship. She will retire
he would not speak anything out of record.
And my Lord, this is not even included in the writ petition, my Lord. If that is so, she should have included this in the writ petition. Why in the rejoinder, my Lord?
It doesn't matter, as long as it's part of the pleadings. The only thing now you have to do is you have
my Lord, even this school, because that will also be incorrect, my Lord, because there are two schools. She is stating Langja, but it is not just Langja, my Lord.
Initially in Langpi, later, Lordship, I have stated.
So how does the certificate says only Langja?
The appointment, Lordship, those appointment
certificate itself is erroneous, my Lord.
Appointment orders, Lordship. Can you see? At Langja Government LP School. That means she was initially in Langpi, for 58 days. Thereafter, another
So how could the
appointment.
certificate say that she is in Langja from 2007?
Also, based on those appointment,
That itself
several
is
appointments,
erroneous.
those subsequent appointments all says that she was teaching in
My lord,
Langja.
just
So the only see among others, this court again I would like to reiterate that the court would like to know the exact status of the petitioner as far as her service in the
Service
school is
continues.
concerned, whether it was continuous from month to month or it was just for 59 days and thereafter there was a break and subsequently the next year she was again appointed and then the next year so on and so forth.
Lordship, as per my instructions, Lordship.
And how do we prove that?
cannot be.
There must be some attendance
Lordship, this
register.
certificate was
There must
also
be
issued by the
certificate, no
Certificate
doubt.
is of no
Certificate,
relevance, my lord.
yes, certificate, certificates are produced on the basis of the facts presented.
Lordship.
You may have said to the, I'm not saying you,
Lordship.
it may have been represented to the authorities concerned that I have been teaching the school for so and so, please give me a certificate.
Yes, exactly.
It could be. We don't know.
We don't know.
Exactly.
The only thing is that at least let us be clear on that point.
Lordship.
You have also, it is also incumbent upon you to to come
Clarify.
clean. Hey, clarify your process.
Lordship.
If that's the case, then your case would hinge on that. Because as far as length of service is concerned, maybe I don't know, the court will have to consider that. Maybe Umar Devi's case would be applicable to you.
Applicable. Therefore, Lordship, we came before this.
And also, you see, you have to understand that after 2010, everyone who teaches is required to have certain qualifications.
Lordship.
NCTA qualification would be required,
Lordship.
for which you have to pass your TT. You have not done that.
I have not done.
Whether you're in such a situation, whether you are qualified to be appointed or teach, those things will have to be considered.
Lordship.
Those things will have to be considered. First and foremost, let us first examine this.
Lordship, if this matter can come up on.
But why is the managing committee not involved here?
No, they never made the managing committee a
Also,
party.
the managing committee is not relevant, Lordship, here
No,
because
but
the
why?
appointment was given by this state.
Yes,
Lordship.
but
Yeah, Lordship. The appointment letter comes from the state.
This is a
Lordship, and I'm
government-aided school.
substituting in place of the
My lord, no, my lord, this is government LP school. my lord.
government LP school.
Government LP
or government LP school.
My lord, it's a-
Also, it's a government school.
Government school, Lordship.
Okay. Well, managing committee will not have any.
Lordship.
My lord, it is a natural thing, my lord, because she is as a substitute teacher. So it is obvious that a person will not be taking, my lord, leave throughout the year.
That is
He
what I-
will be taking leave once in a year whenever it is necessary. So that is exactly why her appointment orders also reflected in the same manner.
So who can clarify before this court as to when that period of 59 days is over?
Yes.
The original teacher has joined and is teaching. You see, which would also be natural that the petitioner would have been out. You see,
Yes, it was.
she can. I mean, two teachers can teach in the same class. That's logical.
My lord, her uncle was the principal.
Annexure.
So in his place, she was the substitute, my lord.
Para 5 of my rejoinder
And my lord,
affidavit, Lordship.
her-
If
the petitioner's own record. First, my lord, the petitioner will have to base her case on the strength of what record she has. My lord, her own record reveals that it is not continuous. Merely claiming will not do, my lord.
Lordship,
Mr.
my
Vichari,
rejoinder
what you do is you
affidavit-
produce your record to show that because since it's a government school,
Yes.
you would have your record on
Well,
the
if
on the leave situation of the incumbent teacher.
Lordship.
He would have applied for leave, and subsequently he may have extended the leave, or he may have, joined. That would be on your record because a joining report has to be filed. If you are out, I mean, if you've been on leave for, in this case, for 60 days, 59 days,
59 days. my lord.
then if you rejoin, you would have to file a joining report. That would be in your record.
And it-
It may not be known to her, but it would be on your record,
Lordship.
which will prove that whether you have joined the service or not. And similarly, See, if you are saying that you have
My lord,
continued to teach,
no, my lord,
rejoinder
another aspect,
affidavit,
my lord.
Lordship, para 5.
My lord, another aspect.
Rejoinder
My lord,
affidavit.
even this very issue of regularization, my lord, the petitioner is by a subsequent writ petition, my lord, the petitioner is automatically barred by estoppel, my lord.
no, that aspect will be looked
Already
into.
barred by estoppel.
That will be looked into. But first, let us ascertain the facts first.
So rejoinder
Because,
affidavit,
my
para
lord, the
5,
petitioner was allowed to participate in a selection process. She did not qualify.
Para 5, Lordship.
Yeah, that's
So
true.
that episode is over, my lord. Again, earlier you have approached this honorable court on the same ground of regularization.
Page 3, Lordship.
You've been allowed to participate in the selection process.
If we are
Now
looking-
again you are coming for regularization.
If we are looking at from that aspect of the matter,
Yes.
perhaps. But first, let us first ascertain the bona fide of the petitioner.
Lordship. Kindly have page 3, Lordship, of my rejoinder affidavit. Para 5, the last paragraph, Lordship, towards the ending, Lordship.
Yes.
It is pertinent to mention, Lordship have it. It is pertinent to mention that though the deponent was appointed on contractual basis for 59 days from the year 2007, but she continued to render her service even after 59 days was over without any interference whatsoever, and received her monthly salary for the same.
You will have to explain why she was allowed to teach beyond 59 days.
Although that is her environment, my lord.
Yes,
The records, but her own records reveal otherwise. Well, this itself is contradictory. Her records reveal that she is, time to time, she is given only temporary appointments, officiating appointments, or as a substitute teacher. Her own record reveals. So her, my lord, merely her statement cannot override what is there in the record, my lord. We will have to go by what is there on the record.
You produce your record. On the next date, we will continue. But you produce your
My
record.
lord, if record is to be produced, my lord, then I'll pray for a longer time, because this is from, my lord, this Langja school is at,
This is Nuez Khasiels.
my lord, so it might take my time, take some time, my lord.
3 weeks. Then.
My lord.
What, Mr. There are counsel for the petitioner. In course of hearing, it is the desire of this court is of the view that the relevant records pertaining to the services of the petitioner, as well as the services of Shri, what's his name?
Fulbidora, Srimiti. Srimiti.
The uncle.
The uncle.
K.
Yes,
Lindau, my
Principal K. Lindau, Lordship.
Principal is the name or the designation?
Principal is the name, Lordship.
Principal Kelinda.
You're saying that he is the principal? So Mr. Principal is the principal.
Sri Principal K. Lindau, Lordship.
PAL,
PAL, Lordship.
Principal K. Lindau be produced on the next date fix. Mr. KP Bhattacharjee, Lieutenant J has submitted that this record may be allowed to be produced. However, a longer date may be allowed, may be given for the same. On pyramid, this is matter after 3 weeks.
Highly obliged, Lordship.
Item number 15.
Yes, Mr. Karmi?
Yes, Lordship, I have gone through the request, Lordship. It has been transmitted back. If Mr. Panti is ready, we can take it up the hearing.
No, transmitted back. You've got, I mean, have you produced the copies?
Copies, I've xeroxed the relevant copies.
Yeah, that is what is required.
Yes, Lordship, I have xeroxed some of the relevant copies, relevant documents.
Yes, Mr. Pandey.
We'll just go through the documents, my lord. We'll just go through the documents, my lord.
It's just the warrant of arrest. It's just the warrant of arrest and the proclamation under section 82 CRPC, Lordship. From the statements, Lordship.
You have been declared absconder?
Yes, Lordship. Yes.
Here, my lord, as I have already stated on the last occasion, my lord, all the coal traders of that particular area, my lord, just based on these allegations, my lord, they were into, my lord, lookout notice against everybody, my lord. So for the sake of that, we were actually not absconder, my lord. We were there in the area itself. And subsequently, my lord, we had approached the Honorable High Court, my lord, for the bail. We had surrendered. We obtained the bail, my lord. We obtained the bail, my lord.
Some of the accused have surrendered and they are on bail. But
that is,
for this instant accused person, Lordship, he was absconding. Okay. He was hiding from the investigation.
And he has not obtained bail till today.
We obtained.
No.
We obtained.
No. He was hiding till the date of filing of the charge sheet. Also, he was
till the date of filing this petition.
Till the date of filing the charge sheet. Also, he was absconding, Lordship.
We have been appearing before the trial court, my lord. We have been taking part in the, my lord, proceedings. We've been taking proceedings. Of course, my lord, what my learned senior is pointing out, those aspects, my lord, in this connections would not have any relevance.
Okay. Let's put it this way. Let's put it this way. That you either deliberately or unintentionally.
Yes, my lord.
You have not appeared before the trial court after the charge sheet has been filed.
We appeared, my lord.
So before the charge sheet was filed?
Yes.
You have not appeared?
We are not actually, initially, we are not aware.
You are not aware?
We are not aware, my lord.
But when the charge sheet was filed?
Subsequently, we got the information that this has been some FIR has been filed, my lord, and there was some lookout notice. So we went to this honorable court, my lord. We came to this honorable court. Then, my lord.
And then you obtained bail?
Yes, my lord.
So after bail is given to you, you appear before the
trial court, my lord. We have been participating in the proceedings, my lord.
That would regularize the
yes,
process.
My lord.
Lordship, as per, if I may submit, Lordship, as per the information received, he was involved, Lordship, in the offence.
No, we are not talking about that.
Yes.
First, on your contention that he, a warrant under Section 82 has been issued, would mean that he has been declared an absconder. Proclamation has been issued, and attachment has been made. Whatever the case may be, we don't know. But the fact remains that on coming to know about the case and the allegation against him, he has approached this court, was released on bail, and subsequently appeared before the trial court. That would be after the charge sheet has been
Lordship.
And then charges have been framed?
My lord, we have argued on our consideration. Yes.
So you have argued, at the consideration of the charges stage.
Yes, my lord.
And then it was
that was rejected. Subsequently, charges also framed, my lord.
We'll proceed from that.
Lordship.
From that point, we'll proceed. It's pointless going back, because that would not be.
For deciding this proceedings, my lord, that will not have any relevance.
That would not have.
My humble submission, my lord.
During the investigation, Lordship, on receiving the information, several attempts were made to arrest him from his residence, but he managed to escape, Lordship.
Anyway, that would be.
And thereafter, the court issued.
Anyway, that would be. You see, that would be a matter of what is the evidence against him by the IO and the charge sheet that was filed. What is there? If there are credential materials available which would implicate him, so be it. If there are no materials, then no materials.
Absolutely, my lord. Here, basically,
we are on that issue now.
Lordship. While deciding this application, my lord.
I've got the charge sheet, Lordship. But Lordship may peruse the charge sheet also, the complete copy of the charge sheet.
Exactly.
Yes, I have got it. Lordship may peruse it. I'll point out the relevant portions, Lordship. To be honest, Lordship, none of the arrested accused person have named him in their statement. That is one thing. And there's page 30, Page 40, Lordship. Lordship, kindly come to page 40. Page 40. Page 40, Your Lordship, got it? Yes. In the middle, during further investigation, the paragraph in the middle. Yes. During further investigation, the accused person, namely Shri Defender Pakam, Poimisana, Wanmidkar, and Shri Kiri Pawa, knowing the fact that they had committed the offence, evaded arrest by absconding in order to escape from the law. That is the observation of the finding of the IO. And I'll take Your Lordship to page 35 also. Page 35. Page 35, issue of warrant of arrest.
Yes.
Issue of warrant of arrest. During further investigation during further course of investigation, reliable source information was received that the person, namely so and so, so and so, so and so, so and so, and this instant accused person were involved in committing the offence. And the next paragraph, Lordship, in the middle, third line, legal proceedings under section 70 CRPC for issue of warrant of arrest was submitted to the court for the accused person, namely Shri so and so, including this instant accused person, and to pave the way for having recourse of section 82 and 83 of CRPC. Accordingly, the Honorable Court issued warrant of arrest in respect of the said accused persons, and issuance of proclamation under section 82 CRPC. Since the warranty, namely so and so, so and so, so and so, so and so, including this instant accused person, remain elusive to evade arrest, and the warrant of arrest could not be executed. So, in order to compel the accused warranty persons for appearance, a prayer to issue a proclamation, section 82 CRPC was submitted to the court, for which the court accordingly issued the proclamation of section 82 CRPC against the said warranty person.
You see, all this records the fact that some of the accused person or many of the accused person, including the petitioner herein, have evaded arrest, not cooperated with the investigating officer, and for which proceedings has been initiated under relevant provision of law. But the fact remains that the IO must have credible evidence to link the accused or to link the petitioner to the offence alleged.
It's on the basis of the information, Lordship, reliable information. And also the fact that he was evading, he was absconding,
that is
hiding away from
that is a different thing.
The investigating agency.
See, that is when he has appeared before the court. Have you sought for
cancellation?
Not for cancellation. Have you sought for for direction by the court to examine him? Have you examined him under 161?
He was absconding. It couldn't be
because eventually he was absconding.
Yes, right.
But eventually he appeared before the court, before the trial court. Of course, by that time, charge sheet has already been filed.
Already filed.
You could have, as far as this particular accused or petitioner is concerned, you could have made a prayer for the court to examine him, to find out evidence against him, and to file a supplementary charge sheet.
Lordship, because after
that has not been done. It's just a surmise. You see, on the basis of information, on the basis of evidence, you find that the accused is, connected or has committed the offence, and that's very
Lordship, because in my humble submission, Lordship, after the charge sheet has been filed, the statement of section 161, Lordship, it's during the investigation.
Exactly.
After the investigation is completed and the charge sheet has been filed, Lordship, that is.
But rightly, what has fallen from this honourable court, my lord, if they find any materials, there is no bar, my lord, for carrying out further investigations and filing subsequent charge sheet, my lord.
The provision is
that is settled law, my lord.
Provision is very much there. Provision is very much there. Even under section 173,
At any time,
173(8), if I'm not mistaken,
it is there.
it is there. But you have not done that. Now, by your own admission, you say that of all the witnesses that you have examined, none has implicated him by name.
Yes.
So, which means that he's not involved.
Yeah, that
Where
is
did,
that is.
so, where did you link him? How did you link him? Because there must be, you see, for putting a person on trial,
Yes.
there must be credible.
Lordship, this status report also, I've got one IO status report, Lordship. If your Lordship may, if I may place it before your Lordship, I'll just point out the relevant paragraphs only in Lordship.
So it is part of the charge sheet. Not part of the charge sheet.
Lordship, yes. We'll see.
But my lord, this is not part of the charge sheet.
No, it's not. Status report is just a report.
Report by the IO. I'll just point out the relevant paragraphs, Lordship. Then your Lordship may pass the necessary order. Item 19. Oh, sorry, Lordship. Paragraph 19. Paragraph 19. 19. Paragraph 19, Lordship. Attempt to arrest the suspected person, Shri So-and-so and Shri Poimisana from their residence at Tuberk Mashnong. However, the suspect managed to escape to the dark as it was night time. So they escaped. And come to paragraph 31 also, Lordship. I'll just point out these paragraphs which are relevant, connected with the instant accused persons. Paragraph 31, Lordship.
31?
31, yes. Paragraph 31. On 10/12/2018, a prayer was submitted to Clariot Court to issue warrant of arrest to the accused person, namely so, including the accused person, and so. And the warrant of arrest was issued, dated 10/12/2018. I have xeroxed the warrant of arrest also. Then come to paragraph 37. Paragraph 37. Paragraph 37. On 21/12/2018, a prayer was submitted to Clariot Court for issuing a proclamation under section 82 CRPC with regard to the accused person, namely so, including this instant accused person, who are absconding and evading arrest in connection with this case, and the same has been allowed and proclamation issued. A WT message was also sent to OCs of Maurankanang PS and Rinja PS for affecting arrest of one accused person. So this is a different accused person. And paragraph 43. Paragraph 43. This is on receiving the information that he is hiding in one of the coal depot. Some police personnel were deputed to arrest him, but he, again, with the help of some people, he managed to escape. On 3/1/2019, an information was received from reliable sources that the warrantee in this case, Shri Poimisana, is hiding in one coal depot on the way to Penthor Sali village. Accordingly, police personnel were deputed to effect arrest of the said warrantee. On reaching the said coal depot, the warrantee saw the police vehicle and flew towards the nearby jungle. On the process of evading arrest, he jumped from the height of 20 feet and landed flat on the surface. As a result, he sustained injury on his back. Later, the crowd gathered and forcefully snatched him from the police and took him towards Tuberk Mashnong. The crowd turned very violent and hostile towards the police and even attacked the police personnel by pelting stones at the police. So he was arrested, he was caught, but with the help of the crowd, he managed to escape again.
You have the copy of the CD with you?
Copy of the I've submitted to your Lordship one copy.
This is the
Xerox
CD.
copy.
This is the CD or the
one I've submitted. I've submitted one copy is there. Xerox copy, Lordship.
No, this is a copy of this is the charge sheet.
Yes, charge sheet.
Have you? Okay.
This is the charge sheet and the status report.
Yeah, on the basis of this status report, everything has to be reflected in the charge sheet.
In the charge sheet. Yes, everything is
when,
reflected.
Suppose now, see, you examine a witness.
A witness.
Could be an official witness or could be anybody who was present. Suppose on, let's for example take this case where you have said that at para 43
Yes.
on 3/1/2019, this is what happened.
Yes.
See, now somebody must have witnessed this.
Yes.
You must have examined somebody who would testify to this fact.
This case, Lordship, a separate police case was registered.
Oh, separate police case.
Regarding this one, in connection with this incident, separate case was registered.
But why would a separate case?
It's clearer PS case.
No. I think this maybe there's some other case, my lord. It is not with regard to this case, my lord.
No, it's mentioned here. In this connection, in this regard, the case is registered again. The unruled cloud, white PS case number, clear PS. Separate case was registered.
If it had been this case, my lord,
Separate
they ought
case
to have gathered
and also,
these
Lordship,
evidences.
with regard to the CDR, Lordship, with regard to CDR, his mobile was continuously switched off. So it was inconclusive CDR also. From that day of the incident onwards. Switch off, continuously switched off.
No, whatever the case may be. See, you say a separate case has been registered, fine. But whatever the case may be, you have noted this point. To link the incident that happened with this case.
Yes.
With the instant case. Where you say is because of this that he has tried to run away and then he fell down and so on and so forth. Then you see, I believe that this case was registered only on account of the crowd which has turned hostile. They have turned hostile. They may be defending him or not, we don't know. But what happened is they have turned hostile and then tried to attack the police, for which a separate case has been registered. As far as this incident of 3/1/2019 is concerned, that's beside the point.
Absolutely.
But the fact remains that this case was registered because the crowd turned hostile. The reason being that they have tried to defend or shield the accused person or the petitioner here. See, so that fact would have been recorded or would have been testified by any of the witnesses in your CD. That should have been reflected. So where is it that such
I think that it will be in that case.
So show me
separate case. That separate case I have it was taken up by another IO.
No, I think
it was taken up by
because he is also implicated in that case.
That one I have to inquire, Lordship. I have to inquire.
But you see, in whatever the case, I think you got my point. Point is, you are saying that there are credible evidence to show that the accused is involved or the petitioner is involved in this instant case. How he's involved? Because he tried to evade arrest. When he saw the police, he fled away, and at some point of time, on such and such date, on 3/1/2019, when the police were about to catch him. He ran away, jumped from a 20 feet wall or whatever, and got injured.
And the crowd
gathered, and you see. So why did he run away? Because you wanted to arrest him or to apprehend him in connection with this case. So all those facts would have been reflected in your CD. Examine so and so. You may have examined any police witness or independent witness, whatever the case may be, but somebody must testify to the fact that yes, this thing happened, we were there. We can point out that he is the person involved. That would have given you, certain materials to proceed against him. But
it is settled law that every case has to be looked upon by based on the materials gathered in that particular case. Cannot be connected to another different case and related to this matter.
We are not talking about subsequent case. In fact, he may not be involved there on any case. See, Mr. Kharmi, what you can do, you have given me this. In fact, you have not even flagged the relevant portion. You understood the query of the court.
Yes.
Try to find out from your charge sheet or from the CD, where are the particular reference made to the involvement of the petitioner. That in such instance, he was here, he was there, he had done this, he had done that. All those things have to be there.
Lordship,
Otherwise, without that, there's, you see, I would agree with
yes,
the petitioner that
Lordship, I've given my submission. I've made my submission, Lordship. It is on the basis of the information received.
Exactly. So you
that he was involved in the offence.
So you flag all those things. It is not here.
And also the fact that he was absconding, he tried to.
All those things.
He was hiding.
True. So from this CD, from this charge sheet, you flag whatever.
Yes. And regarding that last point, Lordship, that one a separate case has been registered. That if your Lordship wish to go into,
that will not be concerned of this court. The only thing is that as far as that incident is concerned, what would be the role of the petitioner or the accused there to link him to this case? That is the only thing you have to demonstrate.
Yes, the incident means the incident which happened in that
on 3/1/2019. Yes. So all those things have to be. Like again, I'm repeating myself. This has to be reflected from the charge sheet. This has to be reflected from the case diary. So you point out that. I'm just citing one incident, one example. There may be others also. You have to prove your case. Otherwise, what happened is filing of framing of charge or consideration of charge by the trial court would have been just on surmises and conjectures. That would not do. You do that 1 week.
Can we have it after 2 weeks, my lord? If on 8th, my lord, if it is okay with this, my lord, if my lord permits.
On 8th,
Lordship,
no.
as I have submitted, Lordship, from the statement also, none of them they have named.
Whatever.
And on the only submission which I have, which I am.
So it means you concede that he has a case.
Lordship, I am submitting only as per the records, on the basis of the records.
I'm telling you time and again.
Yes.
You are submitting as per record, but you have not been able to point out exactly which page. You
Lordship,
can't expect me to read each and every page.
Then I'll just flag mark all those pages which I have referred.
Saying.
Lordship,
you flag mark and point out the relevant portion where the involvement of the petitioner is there, is recorded. Do that.
Lordship, I'll flag mark only those points which I've pointed out to you, Lordship.
Exactly.
And if your Lordship wish to go into that separate case, then I'll have to obtain the instruction again from the IO who's investigating that matter.
That may not be necessary, because that would take its own course. If the petitioner is also implicated in that case, then that would be a different. The only requirement is to link the accused to this case. If at all it is justified to.
There is no direct link, Lordship. I'll humble submit that there is no direct link. I'll be honest with this everything. There is no direct link. It is based on circumstantial evidence.
Even then, that the court will, if you see, then you have to also back up your facts or submission or contention by relevant authorities. But on this matter being called up for hearing, Mr. H. Kharmi, Leonard, additional PP, has produced copy of the relevant charge sheet and the status report of the case, wherein the petitioner has been pleaded as an accused therein. However, the Leonard additional PV would submit that he may be allowed to assist this court by pointing out specific instances of how the petitioner is involved in the case?
Lordship, if I may interrupt, Lordship, I've already pointed out, Lordship. I've already pointed out, Your Lordship, may
by
pass this
flagging.
order. In this warrant of arrest also, Your Lordship.
Yes.
Put,
yeah, that is.
You, Lordship, may
you can give that.
May peruse it.
As is revealed from the charge sheet by flagging the relevant portion. As prayed for.
1 week, Lord.
My humble prayer, my lord, if my lord be pleased enough to fix it on 8th, my lord.
Not on 8th. It may, because I think we have a number of DB matters.
As my lord pleases.
Yes. Only 1 week, Lordship, because that separate case also is not required.
Not required. We'll fix it on 10th then.
10th, my lord.
This is matter on 10th. For further hearing.
Obliged, Lordship.
Well, I will disseminate it. I don't put also after I'll just point out my